Good morning, everyone, and welcome. Can everyone hear me? Good, good. Welcome to our discussion on paid leave, how to remain compliant or become compliant and competitive in 2017. This is a timely topic for employers with employees in the Twin Cities of Minneapolis and St. Paul because, as I'm sure all of you know, due to the level of attendance here today, we will, in a matter of months, have for the first time in the Twin Cities a required paid leave law. This topic is also very timely, however, on a national level. And we'll be talking about that today, too. As paid leave initiatives have been passed in a number of municipalities and states throughout the country, and we expect that these initiatives will continue to be introduced in municipalities and states, and perhaps even at the federal level, despite the change in the administration. Paid leave of various types, is a widely accepted benefit outside the United States. Minimum levels of paid leave are actually required by legislation in most countries outside the U.S. However, in the U.S., the notion of paid leave has been controversial for a number of employers and across a number of industries. Of course, many employers, particularly of a certain size, already provide paid leave to their employees, and even some provide very generous paid leave. We'll be talking about that today, too, some of the things that various companies have done from a competitive perspective to attract talent. Paid leave and similar benefits are actually and very realistically viewed as a major recruiting tool and retention tool for top talent. We've also seen in recent years, interestingly enough, I don't know if any employers in this room have looked into this, but we've seen in recent years employers, notably in the technology area, that have instituted, are considering instituting, or are exploring unlimited PTO for their employees, also as a recruitment tool and retention tool. For other employers, however, depending on the size, the nature of their business, and other factors, paid leave is and will be a financial and administrative challenge, and all of us recognize that. Interestingly, paid leave is probably one of the few bipartisan issues today. The Wall Street Journal, just a couple of months ago, in December of 2016, reported that voters believe that it is either important or very important for Congress and the executive branch to consider legislation for paid sick days as well as paid family medical leave. In this pool, 95% of Democrats and 70% of Republicans agreed with this. 78% of the voters, this was even more interesting to me, said that they would like to see the establishment of a National Paid Family and Medical Leave Act fund that would offer workers 12 weeks of time off to care for themselves or family members. So this is definitely a timely topic, both locally and nationally. We will cover three areas in our discussion today. First, my colleague Ashley will cover and will highlight for us the lay of the land nationally, the national trends regarding paid leave. They're very interesting. We will then discuss our Twin Cities, our Minneapolis Sick and Safe Time Ordinance, and the St. Paul Earned Sick and Safe Time Ordinance that is scheduled to go into effect very soon here. Lastly, we will talk about what employers across the country are doing in a number of industries in terms of offering paid leave benefits. As I mentioned, these are increasingly used as recruiting and retention tools for talent in a very competitive job environment. If you will allow me to do so, before we jump in, Ashley and I would like to ask you all a few questions to do our own little mini poll of the audience. If you could do a show of hands. You don't have to. I don't follow rules either. For those of you who choose to participate, how many of your businesses currently offer paid leave benefits, either a PTO policy or a sick time policy, vacation policy, but I'm not talking about STD or LTD? Okay, just about everybody. Of those that offer the sick or PTO or vacation benefits, how many offer at least 30 hours of those benefits to employees per year? Okay. How many offer 80 or more hours per year as a minimum? Okay. And how many offer a paid parenting leave, separate from PTO? Interesting, many, many fewer. I have more clients talking to me about that, really as a recruiting tool. How many of your businesses have offices in Minneapolis or St. Paul? Okay. And if you don't have offices in St. Paul or Minneapolis, how many have a substantial number of employees who regularly work in the Twin Cities? A few more, okay. And does anybody have employees outside of Minnesota in the 5-state area? And how about beyond the 5-state area? Does that give you enough of a sense, Ashley? I do what Ashley tells me. She came up with these questions. How many have a total employee population of 21 or less employees? 21 to 50? 50 to 100? 100 to 500? More than 500? Thank you. Boy, everybody participated. Moving on to our agenda then, we will begin with a discussion of the lay of the land on a national level regarding paid leave.
Thank you, Anne. As Anne noted, the first topic is national trends. So we're going to talk about where our country is with regard to paid leave and where we anticipate it might go in the future. Before we get into that, I just wanted to make sure we're all on the same page with regards to terminology. So unless we say otherwise, when referring to paid leave, we're including two things within that. That is paid family and medical leave, which includes time off for having a child, adopting a child, bonding with the child, as well as tending to serious medical conditions. Also included in that broad category is paid sick leave. And that includes not only the more serious medical conditions included in the first category, but also the lesser serious illnesses and conditions that might force an employee to call in sick to work, including the flu and things of that nature. So unless we clarify otherwise, we're referring to both of those in the general terms of paid leave. So let's dive into where we are at as a nation today with regard to paid leave. As I'm sure all of you know, there is no federal mandate for paid leave, that employers have to give their employees paid time off for either sick leave, medical, or family leave. And the closest thing we have to it is the Federal Family Medical Leave Act, the FMLA. And that requires employers to give eligible employees up to 12 weeks of unpaid leave for qualifying events, such as having a baby or suffering a serious medical condition. Additionally, there are other federal statutes, such as the ADA and Pregnancy Discrimination Act, that may require leave as a reasonable accommodation, but that is more of a case-by-case basis and in general is also unpaid leave as well. Despite this, most Americans want and need paid leave for family leave, medical leave, and sick leave, but don't have access to it. Let me give you some numbers that will illuminate this situation. For the family and medical leave, according to the Department of Labor, only 60% of American workers are covered by the FMLA. Again, that is unpaid leave. This includes less than 1/5 of new moms. When you look at paid leave, only about 12% of American workers are entitled to paid maternity leave. And this number drops to 5% for low-wage earners in the bottom quartile. Given this, research shows that a quarter of all women in the United States return to work in less than 10 days after having a baby. 10 days. This is because they either can't afford to take time off or they don't have access to leave. And in the same election survey that Anne had noted in her introductory comments, where polls were taken right around the time of the 2016 election, 71% of respondents said that they and their families would suffer significant financial hardship if an immediate family member became seriously ill or if they had a new baby. 71%. With regard to sick leave, we fare a bit better. With the United States Bureau of Labor and Statistics say that about 2/3 have access to paid sick leave, and that's representative of your voting today. Others have to face the choice of coming to work while sick or trying to figure out other accommodations. So it is no wonder why lots of Americans are now pushing for paid leave, not only paid sick leave, but also paid family and medical leave as well. So here is where we are at in terms of the country. 5 years ago, in 2012, this was the lay of the land. As you'll see, there are no states that required paid family and medical leave, and one state, Connecticut, required paid sick leave. That was passed in 2011. And there are a couple of states that have cities that had legislated paid sick leave. 3 cities, to be exact, in 2012 required paid sick leave, and that's Seattle, San Francisco, and Washington, D.C. So where have we come from there? In the last 5 years, this trend has exploded. As you'll see from this timeline, both states and municipalities have enacted paid sick leave and or paid family and medical leave. This is a representation. I'm sure there are probably some out there that I've missed, but as you can see, there are a lot. In total, as of when I looked yesterday, there are 39 total jurisdictions that require some sort of paid leave. And here is another illustration, a map showing how all of this breaks down across the country. As you can see, it's a wide spectrum between states that require both paid family leave and paid sick leave to states that outright ban localities, don't have any legislation, and ban localities from legislating on it as well. So let's start at the top. Only one state requires both, and that's California. It requires both paid family and medical leave as well as paid sick leave. Additionally, it doesn't have a preemption requirement that outlaws municipalities from also legislating. So you'll see there are a number of green stars, which indicate cities that have their own sick leave ordinances. So you can see there's a handful, including San Francisco and Los Angeles, Santa Monica, to name a few California cities that have their own sick leave. On the other end of the spectrum are the red states, and those are states that don't have any law on the books, and they also prohibit localities from legislating on this issue. Interestingly enough, Wisconsin is included in that, and back in 2008, Milwaukee actually passed via ballot measure a sick leave ordinance, pretty overwhelmingly. That was in 2008, and then in 2011, Wisconsin passed their preemption law, which essentially invalidated that Milwaukee measure. So then you move towards the middle. Green states are states that require paid family and medical leave. There are 2 categories of green states, but green in general represents paid family and medical leave on a statewide level. Dark green, which it's hard to see, the only one is Rhode Island. And that one represents there's no sick leave complications in there. The light green, which are New York and New Jersey, are states that require statewide family and medical leave, but also have municipalities that require paid sick leave. So in New York, that includes New York City. In New Jersey, there are at least 12 cities that require paid sick leave. As you'll see, I tried to get a whole bunch of stars in that little state of New Jersey. Then The blue states are states that require paid sick leave. And you'll note in some of those states, including Washington and Oregon, there are also municipalities that have their own requirements as well. Interestingly enough, Arizona and Washington were ballot measures as well, and as was Massachusetts. So all three of those states were enacted by the voters pushing for paid sick leave. And then we move to the yellow states, which are states that currently don't have a statewide requirement, but do have municipalities that require paid sick leave. And that includes Illinois. In Illinois, it's Chicago and Cook County. Pennsylvania is Pittsburgh and Philadelphia. There's Maryland in there, and of course Minnesota now with the St. Paul and Minneapolis sick leave. And I just saw that Duluth is also now opening up a task force looking into their possible ordinance of paid sick leave as well. One thing to note, though, is that Minnesota, there are 2 bills pending in the legislature, which are representative of both of these trends. So one of the bills is seeking to prevent municipalities from enacting paid sick leave. And so under this bill, if it were to pass, the Minneapolis and St. Paul ordinances would be invalidated just like the Milwaukee measure was. However, in order for that to happen, it has to pass both houses and the governor has to sign it. So whether the governor would actually sign it is debatable. The second set of bills is a set of bills that would require paid family and medical leave. And it sets up a fund similar to unemployment insurance, in which both the employee and the employer contribute into this fund that would help offset some of the costs of the paid family leave. So that's also pending in the houses right now, which would also have to pass both houses and get signed by the governor. So keep your eyes and ears open for those developments, because those obviously will impact the local ordinances and employers outside of Minneapolis and St. Paul. So where are we headed? I think based on my comments, you can tell that this trend is likely to continue and probably accelerate. As Anne noted in her introductory comments, a vast majority across bipartisan support paid leave. And the research shows that voters are voting for politicians who support paid leave. And there is also research indicating that voters are wanting to penalize candidates that don't support paid leave. And so it is very likely that either there will be ultimately a national mandate, or in the absence of that, the states and the municipalities will continue to legislate in that absence. So with that, I will turn things back over to Anne so that she can discuss with you what you need to know with regard to the Minneapolis and St. Paul sick leave.
Yes, before I get into that, I was told that you have these little forms to put your questions on. If you fill those out, if you have questions, and send them to one end of the aisle or the other, those will be collected, and we'll certainly cover those. So interestingly, apart from the Twin Cities ordinances, which I will talk about very, very soon, there are a lot of competing forces at play in the state. Ashley mentioned the various bills that are making their way through the House and the Senate, and we'll see what happens with those and what the governor does with those. Some of them trying to give fairly expansive paid leave rights, and others trying to essentially, by saying that municipalities shouldn't institute those ordinances separately, are trying to sort of take paid leave off the table. In those pieces of legislation, it's not entirely on our topic, but I know it's of interest to folks. In the legislation that is aimed at directing municipalities that they cannot legislate on paid leave, it also includes a direction that they can't legislate on minimum wage. So there are a bunch of different things in those bills that are of interest. The other thing that's occurring, and many of you have probably read about it in the paper, is the Minneapolis Sick and Safe Time Ordinance was challenged in Hennepin County District Court. The judge issued a decision recently that indicated that one portion of the law was essentially outside the jurisdiction of the city to make. It's a small portion of the law. It's the portion of the law that says that if you have employees that work only 80 hours or more in the cities, it's in both the St. Paul ordinance and the Minneapolis ordinance. If they work a minimum of 80 hours only annually in the city, they would be entitled to sick and safe time. And that portion of the law for now has been struck down. We don't have, it's on appeal, of course, by both sides. We don't have a crystal ball. My thought, it's just my personal view of this, is that the lower court's decision will be upheld and then that the Minneapolis ordinance will, in large part, be enforced. The St. Paul ordinance has not been challenged. We're certain that they're doing a wait and see to see what the courts do with the Minneapolis ordinance. We will continue to keep you posted on all of these developments by our usual flash focuses. If you are not signed up on our flash focus list, let us know and we'll get you on that. Another point before I get into the ordinances themselves, St. Paul has indicated that they're going to be issuing guidances in April 2017 regarding the interpretation of their ordinance, and Minneapolis is indicating that they're going to issue theirs the day before it goes into effect. Am I right on that? It's like, wow, how helpful is that? I'm really impressed with that one. So, without further ado, let's talk about these ordinances. I'm going to deal with the Minneapolis ordinance first, and then I'm going to deal with the St. Paul ordinance. It is similar to but not identical to the Minneapolis ordinance. So the Minneapolis Sick and Safe Time ordinance goes into effect on July 1 of this year. Employers with 6 or more employees must provide paid leave. Employers with 5 or fewer employees must provide unpaid leave. It applies to private employers. It applies to the city of Minneapolis. It does not apply to county or other local government, state of Minnesota, the U.S. government. As originally drafted, and this is the piece that was determined by the district court judge to be unlawful, essentially. I won't go into all the details of the basis for that decision. As originally drafted, the ordinance applies to employees who work at least 80 hours per year in the city of Minneapolis. It applies to employees that are full-time, part-time, temporary, doesn't matter. If they're W-2, it's going to apply to them. Independent contractors are not covered. The only caveat I give to that, you've probably heard many of us talk about how the IRS and other agencies are very focused on misclassification issues. So if you are in the city of Minneapolis and this ordinance otherwise is going to apply to you, and you have independent contractors, just make sure that you are comfortable that they are true independent contractors, and maybe check with your counsel to see if there may be some misclassification issues there. The core of the law says that eligible employees accrue 1 hour of sick and safe time for every 30 hours of work to a maximum of 48 hours per calendar year. They define calendar year as really any 12-month period that is established by the employer, but the ordinance talks about calendar year. Of course, you can always provide more time than the 48 hours, but this is what the ordinance requires. Exempt employees are deemed to work 40 hours per week unless they have a regular work schedule that's less than that. Employees can begin using the time after the first 90 days of employment, and employers have the right to cap the accrual, the maximum carryover for 1 year, one 12-month period to the other, to 80 hours. The sick and safe time, and this isn't anything unusual, the sick and safe time, like any vacation time or sick time, is paid at the regular rate of pay. You don't have to work in commissions, expenses, reimbursements, overtime, et cetera. The ordinance does not require that you pay out the sick and safe time as of resignation or termination of employment. You can, but it's not required. This is a little bit of an odd provision in the law. When Ashley and I were first looking at it months and months ago, we were saying, what are they doing here? And now I guess I get the logic. You can satisfy the obligations under the Minneapolis ordinance by providing at least 48 hours of sick and safe time following the initial 90 days of employment for use during the 12-month period. Remember, where we say calendar year for Minneapolis, it can mean the 12-month period established by the employer. So it's probably going to be either your employment anniversary year or your fiscal year or calendar year. So you can satisfy your obligations under this ordinance by providing 48 hours as of following the initial 90 days of employment, and then at least 80 hours for every calendar year thereafter. You, of course, this is important, and a lot of my clients, I've been reviewing their policies, a lot of my clients' policies already more than comply with the ordinance because they're much more generous than the ordinance. Sometimes I have to adjust carryover and things like that. But employers are not required to provide additional leave if the employer policy meets the minimum standards of the ordinance. We are hoping that the guidances that are going to come out of Minneapolis and St. Paul are going to explain a lot of this in a little more detail. I'm probably being a Pollyanna in saying that, but maybe they'll provide us with some clarification. Under the Minneapolis ordinance, I call it the new business exception. There is an exception for a new business in the first 12 months after hire of your first employee. So if you start your business, you hire your first employee today, this 12-month period going forward, you're required to provide unpaid time, but not paid time. This exception is going to go away June 30 of 2022, and it does not apply to chain establishments. Is anybody in the room involved in a business that is a chain establishment? No. Okay, I'll move on. There are special circumstances for healthcare providers. Healthcare providers are defined in the ordinance. They are folks that are licensed in good standing in Minnesota to provide medical or emergency services. They are employed at an hourly rate that is at least 4 times the federal minimum wage, and these include doctors, nurses, and emergency room personnel. The healthcare provider is entitled to accrual of sick and safe time only when scheduled to work, and they're not deemed scheduled to work if they call in and request a shift. On-call shifts are not counted unless they're asked to remain on the premises. Is anyone in the room in the construction industry? Okay. The construction industry may opt to comply with both the Minneapolis ordinance and the St. Paul ordinance by paying at least the prevailing wage rate set forth in the statutes. And if you've got questions on that, feel free to check with us afterwards or send us a question. For those of you not in the construction industry, and if you think this is unfair, the prevailing wage rate takes into consideration a lot of things. It's not just what you would think of as a regular hourly rate. So really, the construction industry is already paying construction employees, to compensation for sick time. And this is only with respect to construction employees. So what can the employee use the sick and safe time for? Many, many, many things. And these are all defined in the ordinance. I always look for an overall sort of easy way to look at this. Essentially, they can use this for just about anything related to their own health condition, a family member's health condition, and in some instances where places of work and schools have been closed for various reasons. So they can use it for an absence due to the employee's physical, mental illness, injury, condition, need for medical diagnosis, et cetera, need for preventative medical or health care. They can use it for the care of a family member with a mental or physical illness, injury, or health condition. It mirrors the definition with respect to the employee's own. They can use it for an absence due to domestic abuse, sexual assault, or stalking of the employee or the employee's family member. Now, for those of you that operate in Minnesota, we already have a requirement to allow folks to use PTO for those purposes under a different statute, so that's not unfamiliar to us. They can use it for an absence due to the closure of the place of a business by order of a public official, not something you'd want to have happen, but I suppose we're talking about restaurants, to accommodate the employee's need to care for a family member whose school or place of care has been closed by order of a public official, or to accommodate the employee's need to care for a family member whose school or place of care has been closed due to inclement weather, loss of power, loss of heating, loss of water, etc. Family member is very broadly defined. It includes any type of child of the employee, their spouse, their registered domestic partner, their sibling, parent, step-parent, mother or father-in-law, grandchild, grandparent, guardian, ward, members of the household. And domestic abuse, sexual assault, and stalking is as defined in Minnesota's criminal statutes, which are very, very broad. As you have questions, as you're starting to implement these, the requirements under the two ordinances, and you get a request that seems a bit odd, the best thing to do really is either call your attorney and ask them to check to see if whatever the employee is suggesting is actually covered by the sick and safe time accrual right, or call over to the Minneapolis Department of Civil Rights, and they do have on their website, they do have a phone number for questions. They, of course, will, interpret the law very, very broadly, just so you know. So, employee documentation. There are a number of requirements under the Minneapolis ordinance in terms of record-keeping, documentation, and notice. And I'll just go through some of those. So an employee must be provided upon request their accrual, whatever their accrual is and whatever they have used. I imagine that a lot of employers already report PTO accrual and use on a pay stub. That can suffice, but if an employee requests that information, you should absolutely have that information and provide that to them. There's also a posting requirement. For Minneapolis, there is a notice that has to be posted in all languages spoken by at least 5% of the workforce at a site, at a job site. The notice has to be posted at the job site, at each job site. And it also, there needs to be a notice of rights in the employee handbook. And we can help you with the notice of rights in the employee handbook, or you can contact your attorney to get a sample of that. There are strict confidentiality requirements. This isn't a surprise to all of us that deal with employment situations. Any information regarding someone's medical condition or the private information of their family members should be kept in a separate file. So if you've got documentation from the employee about the stalking or sexual assault of a family member to justify taking the requested paid time, that should be kept in a separate file. It makes sense, right? But it's actually required, and that's required by both ordinances. In terms of record-keeping requirements for the employer under the Minneapolis ordinance, the employer has to maintain records, and this means that if these are requested by, the Minneapolis Department of Civil Rights, if there's a complaint made, you've got to be able to produce all these. For non-exempt employees, the hours worked, you're going to have that anyway, because for your non-exempt folks, you've got requirements under the federal and state wage and hour laws. The hours of leave available for sick and safe time purposes, the hours of leave used for sick and safe time purposes, and this must be retained for not less than 3 years. I always add a year when I see an ordinance or statute, just to make sure that things aren't inadvertently destroyed. There is a prohibition against retaliation or discrimination, and this is familiar to all of us. It's built into absolutely every employment-related law, that you can't terminate somebody or take adverse action against them because they've requested leave under the statute, because they made a protest that they weren't given their rights under the statute, because they filed a claim with the Department of Civil Rights, any such thing. Retaliation is prohibited. If the leave is foreseeable, and this will be familiar to you from your dealings with the federal family and medical leave and your state parenting leaves in the various states in which you operate. If it's foreseeable, an employer may require advance notice, but they can't require more than 7 days advance notice for use of sick and safe time. If it's not foreseeable, the ordinance says that the employee is required to give notice as soon as practicable, probably calling in the day that they're sick. The employer can require reasonable documentation of the need to take accrued sick and safe time. Many of our employers have policies that if you are absent for 3 consecutive days or more, that you're required to bring a doctor's note. Of course, if the family medical leave is going to kick in there soon thereafter, but a lot of our employers have that in their policies, even if the FMLA doesn't apply. And so under the Minneapolis ordinance, you can require reasonable documentation if the leave is going to be 3 consecutive days or more. You cannot require the employee to find a replacement. That makes sense. I mean, I imagine under your PTO policies, when people call in sick, you don't say, well, you got to get somebody to come in and do your job. I wish I could do that when I was sick. Can you just come in and do my job for the day? Move that ball along. And there is an enforcement mechanism under the ordinance. So an employee can make a complaint, make a report that the employer is in violation of the law. The employee has to make the report within 365 days of the violation. And the process goes more or less the way the process would go if you were defending a charge of discrimination before either of the city agencies or the state human rights department. The employer has a certain amount of time to get in a position statement. The department does an investigation and issues a decision. There is real money attached to violation of both the Minneapolis ordinance and the St. Paul ordinance. So if the person has been terminated in retaliation for pursuing their rights under the ordinance, they would get reinstatement and back pay. That makes sense. That's typical of employment statutes. They get credit for their sick and safe time. And there are penalties of 2 times the value of that, or $250, whichever is greater. There's the potential for an administrative penalty of $1,500 and other penalties depending on the nature of the violation. The Minneapolis ordinance does say that in the first 12 months, they are going to issue warnings to correct, and then if you don't correct, they'll move forward. We'll move to the St. Paul earned sick time and safe time ordinance. Of course, St. Paul had to put that little earned word in it so they could be unique and distinctive. So the St. Paul ordinance goes into effect on July 1 for employers with 24 or more employees. For smaller employers that have 23 or fewer, they've got a little extra time. It's January 1, 2018. It applies to employers with one or more employees, and there's no special treatment for smaller employers that you have with the Minneapolis ordinance, that if you're a very small employer, you can provide unpaid leave. Like the Minneapolis ordinance, it applies to private employers, the city of St. Paul, and it doesn't apply to the county, the local government, state of Minnesota, U.S. government. As originally drafted, and actually there hasn't been a challenge yet to the St. Paul ordinance, but it applies to employees who work at least 80 hours per year in the city of St. Paul. Like the Minneapolis statutes ordinance, it applies to full-time, temporary, part-time, W-2 workers. Independent contractors are not covered. My same caution about potential misclassification there, as I said, with the Minneapolis ordinance. The accrual is the same as the Minneapolis ordinance. The accrual is 1 hour for every 30 hours of work to a maximum of 48 per calendar or fiscal year. It accrues in 1 hour increments. That's the same as the Minneapolis ordinance. It doesn't accrue in partial hours. And I didn't mention this, I apologize, for the Minneapolis ordinance. When it goes into effect on July 1, 2017, the accrual for current employees begins as of that date, so it's go forward. And the same is true for the St. Paul ordinance. As with the Minneapolis ordinance, employees can begin to use time after the first 90 days of employment, and you can institute an 80-hour maximum carryover. Your sick and safe time is paid at the regular rate and does not need to be paid on termination. So you see it looks very, very similar. You can meet your obligation under the St. Paul ordinance in the same way you can under the Minneapolis ordinance by allowing 48 hours of sick and safe time following the initial 90 days of employment for the first year, and then 80 hours for each subsequent year. As with the Minneapolis ordinance, if your current policy is more generous or it at least meets the minimum standards of the ordinance, you do not have to offer additional time accrual. Their new business exception, as I call it, is a little different. The St. Paul ordinance says that new employers may provide unpaid leave for the first 6 months of hiring the first employee, not the first 12 months like in the Minneapolis ordinance. And this exception is due to go away in 2023. Those years just sound surreal to me. I just can't imagine being in the year 2023. You probably can. There's what an ageist remark. No special treatment for healthcare workers under the healthcare providers as under the Minneapolis ordinance. The same exception applies to the construction industry and construction workers, that if you're paying at least the prevailing wage rate, and that you're paying it regardless of whether the employees are working on public or private projects. That's the same as Minneapolis. You're deemed to have complied with this ordinance. The wording of the instances where the employees can use the accrued time is a little bit different, but the sense of it is pretty much the same. An absence due to the employee's mental or physical illness, injury, or health condition, etc. Similar to the Minneapolis ordinance, an absence for the care of a family member with a mental or physical illness, injury, or health condition, etc. Domestic abuse, sexual assault, an absence due to all of those things, or stalking of the employee or an employee's family member. You see the same absence due to the closure of the place of business by order of a public official to accommodate the need for an employee's to accommodate the employee's need to care for a family member whose school or place of care has been closed by order of public official, and to accommodate the employee's need to care for a family member whose school or place of business has been closed due to inclement weather, loss of power, loss of heating, etc. A family member is defined similarly under the St. Paul ordinance as it is under the Minneapolis ordinance, but it's not identical. So as with the Minneapolis ordinance, any family member includes any child, stepchild, adopted, foster, adult child, spouse, registered domestic partner, the employee's sibling, parent, step-parent, mother or father-in-law, grandparent, grandchild, and an individual related by blood or affinity whose close association with the employee is the equivalent of a family relationship. So basically anybody living in the household, I think. Domestic abuse, sexual assault, and stalking are all as defined under the Minnesota criminal statutes, which go on for pages and pages. It's a very broad definition. In terms of documentation, you see the same or very similar requirements as under the Minneapolis statute. One further comment before I get into that. Under the St. Paul ordinance, the ordinance requires that the time be provided to the employee, the leave be provided to the employee upon the employee's request. It says that the employer, and I'll just read the language because I'm hoping we'll get more guidance, and the employer may require an employee to comply with the employer's usual and customary notice and procedural requirements unless those interfere with the purpose for which the leave is needed, whatever that means. But essentially, I think if you've got reasonable notice and procedural requirements under your policy, it's going to pass muster. You might want to have your attorney just take a quick look at that. The employer may require reasonable documentation for the absences if the absence is 3 consecutive days or more. And as with the Minneapolis ordinance, the employee cannot be required to find a replacement. So similar in terms of employee requests for documentation and information, similar to the Minneapolis ordinance, if an employee requests it, they must be provided with what their earned time is and what their used time is. Makes sense. There is a poster requirement. The poster will be, as with Minneapolis, issued by the Department of Human Rights and Equal Employment Opportunity in St. Paul, the Department of Civil Rights in Minneapolis, and there must be a notice of rights included in the employee handbook. Very, very similar strict confidentiality requirements are in the St. Paul ordinance. Medical information, personal information on family members, et cetera, should be kept in a separate file. And we would be telling you that anyway. We would say do not keep any of that in a personnel file that a supervisor or a manager or someone who shouldn't be seeing that would have access. In terms of record-keeping requirements, they are very similar to Minneapolis. Employers, if requested by the department, must show the hours worked by the employees. Again, you would have these records at any rate because you need to have them to comply with your requirements under the federal and state wage and hour laws. You would have to produce records of sick and safe time taken and sick and safe time accrual. There is a strict prohibition against retaliation or discrimination also in the St. Paul ordinance. The St. Paul ordinance has its own similar but not identical enforcement mechanism. There is the ability to bring an action in civil court. There's also the ability for an employee to file a complaint with the Department of Human Rights and Equal Employment Opportunity within 365 days of the alleged violation. The process is similar in terms of the employer response, as the employer response would be to a charge of discrimination before the state human rights department or the city agencies. The city issues a determination. They are able, if there's been a termination that's viewed to be in retaliation for rights under the ordinance, they have the ability to order reinstatement and back pay, which is typical. And then the St. Paul ordinance has a escalating penalty depending on how many violations you've had. For your first violation, it's one level of penalty, and then it increases with the violation. With that, I am going to turn it over to Ashley to talk about what some of the businesses are doing nationally with paid leave.
So because Frederickson is where law and business meet, we genuinely care about how these laws and trends affect both you and your businesses. And this includes not only becoming and remaining compliant, as well as being competitive and really thriving either in spite of these trends or because of these trends. And so in order to figure out how to be competitive and thrive, it helps to know what the competition is up to. So I'm going to spend the last part of our presentation giving you a look into what some of the other businesses are doing in terms of the paid leave trend. So this first slide shows various businesses throughout industries incorporating paid leave, and this is paid parenting leave specifically, in an effort to retain and attract top talent. And this was pulled from a crowdsourcing website, and you can go on there and look at all kinds of different industries and see what type of leave different businesses are offering. As you can see, and as Anne noted in her introductory comments, some of the technology companies really are going all out with this, with Netflix at 52 weeks. You see Microsoft and Google on there, but you also see different industries as well, including Caterpillar, DHL with the delivery services. You also see restaurants and service industries with Starbucks and Chipotle. So it really is fascinating to see how businesses are using leave as a recruitment tool and as a way of keeping employees employed as well. I actually came across an interesting statistic when preparing for this presentation that said that the average cost of replacing an employee is about 21% of their annual salary. And I thought that that was fascinating, given that a lot of the research shows that if women are unable to have paid leave or have leave, that the numbers of them dropping out in the workforce increases. And so offering paid leave as a way to not only get those employees back, but also cut out those costs of having to replace and train that employee is also an interesting thing to keep in mind. Another article I came across indicated that at Google, so as you see on here, Google offers 20 weeks. That when Google increased to 20 weeks, the CEO indicated that the rate at which new moms fell by 50%. So there are numbers out there that support the fact that offering paid leave does incentivize employees to stay and does make happier, more productive employees.
Is this sick time and vacation time together, or is it just sick time?
So this slide is just paid parenting leave. Yep, this is just paid parenting leave. And so you bring up a good point, though, in terms of sick leave. There was a study done back in 2016. It was published in July of 2016 that indicated that it compared rates of the flu, statistics on rates of the flu, compared to cities that enacted paid sick leave. And it showed that in those cities, flu rates dropped by about 5% after the laws went into effect. So hopefully that they are encouraging employees to stay home when they're sick and not spreading them while they're sick.
Does that take into consideration any for males?
So some of, you're talking about this slide? Yeah. So some of them do. It's probably hard to see, but the ones with the asterisks have different male paternal leave than maternal leave. A lot of them do have more generous maternal leave than paternal leave, but some of them, I believe Netflix, the top ones are just parent leave across the board. So that is a good point. one other thing to note is that, as I mentioned in the first part, that Americans really are looking for paid leave, which means both that they're more willing to stay with an employer or be happier with an employer if they're getting it, but it also means that as consumers, they're more willing to pay money to companies that have generous leave policies. So in that survey that I had referenced earlier, the election survey, it had found that 58% of voters were more likely to spend money at a company that offers products and services that they need if they knew that the company offered generous family medical benefits to their employees. And you'll see this, not necessarily the consumer trend, but you'll see the trend towards using leave as a bargaining chip to become more competitive just by doing a simple Google search. And you can pull up countless news articles about the banking industry trying to become more competitive, the technology industry. All these industries are fighting for top talent, and this is one way in which they try to get a leg up off the competition. And so based on one of those articles, here's another depiction of companies that have increased their paid, and again, this is paid parenting leave, I believe, exclusively, all within the last year. There's a big article in the Star Tribune about 3M increasing their policies, and you'll notice again that it crosses a variety of industries, from the banking industry to professionals and IKEA with retail as well. But we are not unsympathetic to the fact that a lot of these companies are big companies, and some of you are big companies, but some of you are small companies as well. And so we also want to be here for you to try and help you figure out how you can both be compliant and competitive, even as a small company. And one last statistic, because I'm a bit of a nerd, as you can tell with all these numbers. California is one of the states that require both paid family and sick leave, if you'll remember that from an earlier slide. And after they implemented their paid medical leave, the Family Medical Leave Act, a survey in 2011 was done, which found that 91% of employers said that the policy either boosted their profit or had no effect at all. And another portion of that survey indicated that about 2/3 of employers reported no increase in cost, and then an additional 2% said that, or excuse me, an additional 19% said an increase of 2% costs. So we acknowledge that there are costs, but given the benefits that also come with paid leave in terms of a healthier workforce, hopefully, a more happy and productive workforce, as well as cutting out those costs of having to find and retrain talent. Hopefully those end up either leveling out or even making you more competitive as a business. So we are happy to help in any way we can, both in terms of helping you be compliant, but also thriving and being competitive, just in spite of these trends as well. So with that, I will turn it back over to Ann.
So please do send your questions or raise your hand, and Kelly will pick up your questions. Either send them to the end of the aisle or raise your hand and she'll pick up your questions. I also wanted to give a plug for our employment law guide that we put together every year. I will tell you that I actually use this myself. So if I want to remind myself of a particular state law, federal law, just the basics of it as part of something I'm advising on, I actually pull this, and I know my partners do too. I think it's very well written. Our fearless past chair was in charge this year of updating it. And it covers federal, Minnesota, Iowa, and North Dakota law. And so if you're interested at all, let any of us know, and we'll get you the information on that. So just as takeaways, and then we will get to all of these questions, these paid leave initiatives are likely to continue, and we will be monitoring them and keeping you up to date. Basically, where the public is in support of something, we all know that in the United States, legislation follows. I mean, that's just the way it is. It doesn't really matter who's running the country at that point. By the same token, individuals continue to factor into their decisions, and I know I hear it from young lawyers that are looking to join a firm, and I hear it from my clients as they're trying to recruit people, that top talent takes into consideration paid leave benefits, vacation benefits. They take into consideration benefits now. They are much more deliberate about that than I ever was when I was looking to join a firm or a business. For those employers based in the Twin Cities or who have employees in the Twin Cities, you'll want to watch for our flash focuses to define for you who really is going to be covered by this. We know that if you're based in the Twin Cities and your employees are working here, I mean, you're covered. But how it's all going to play out in terms of folks, businesses that are based outside the Twin Cities but have folks in the Twin Cities that work significant hours in the Twin Cities or regularly work in the Twin Cities, that really, in my mind, is an open question. The ordinances are not well drafted in that regard. In some regards, they're clear, but in that regard, I don't think they are. I'm hoping that these guidances that come out, the one for St. Paul in April and the one for Minneapolis in June, will clarify that. But we can help you in the meantime. If you are wondering, you know, I'm in a gray area, does this apply to me? Give one of us a call, because we will give you our best advice on that and monitor that for you. And as always, we're here to help you in any way we can with your policies, with your processes and your questions, and we will keep you updated as the months and years go forward here. So I have not gone through these questions. Should I just take a few?
Sure,
And do you want to
yeah,
take
go
a few? You know, there are a lot of questions about, I can see that there are a lot of questions about, will the ordinance apply to me in this particular situation? I'm going to give you my best guess, but I have to tell you that right now, we're still waiting on some definition of that. So if an employee fills in at a Minneapolis site but regularly works at a non-Minneapolis site, would they be covered? It's an open question in my mind. Wouldn't you agree, Ashley? I think it's an open question in my mind. Under the ordinance as originally drafted, if the person worked at least 80 hours in Minneapolis, they would be covered. But we have to wait and see on that. How would the sick and safe time ordinance affect our current attendance policy? Are employee absences still disciplinable? I love that word, disciplinable. Are we able to put them through the corrective action process? Well, if an employee is entitled to take sick and safe time, we can't discipline them for it. So that is something that we have to watch there. I suppose similar to if somebody's entitled to time under the Family Medical Leave Act, you can't discipline them for it. If they have a right under the ordinance to the time and they meet the requirements, they're entitled to that time and shouldn't be disciplined for it. Does the Minneapolis, you indicated that the Minneapolis ordinance applies to full-time, part-time, temporary employees. Does it also apply to interns? The interns, I presume, are W-2 employees. I would say yes. It is not specifically addressed in the ordinance. We will let you know if there are any nuances on this as the guidances come out, but I would say yes to that at this point. Do you want to take a few, Ashley?
Sure. So this person wants to know how how these ordinances affect PTO policies with a clawback. And I believe Anne had sort of touched on this, but I'll elaborate a bit more. The actual statutes do not require that you pay out the sick time upon termination. However, the individual employer's policy is what would dictate under those circumstances. So there are other Minnesota laws that dictate when and what needs to be paid out upon termination. And those largely defer to what the employer's policy is and what the employer's rules are. And so in terms of the ordinances, they don't necessarily affect paid time going back, if that makes sense, upon termination. And then the second question that I have here asks whether the prevailing wage rate only applies to construction employees working on a job in St. Paul or Minneapolis. And so they're referring to that portion of the ordinance that allows construction industries to use the prevailing wage rate instead of paying the paid sick leave. And in that circumstance, that would be employers who are in Minneapolis or St. Paul would be covered by that statute. So any employers who are covered at that time would have to offer the offer the prevailing wage to their employees in those municipalities. A couple more?
Sure. These questions are excellent. If I have employees who work on job sites in both Minneapolis and St. Paul, do the work hours in each city need to be tracked separately? Do both ordinances have an effect on those employees, even if my company is headquartered in Minneapolis? So in large part, we're going to have to wait for a definitive answer on this until we get some guidances from the Minneapolis and St. Paul. But I would say if you have operations in both St. Paul and Minneapolis, the accrual rates, the basic accrual rates under the two ordinances are the same. So I don't think you would have to track, the accrual rates and the use of those the same. But if you have folks in both, if your company is headquartered in Minneapolis, but you have employees in both Minneapolis and St. Paul, the ordinances do not answer this question. I would imagine that we're going to get some guidance from St. Paul and Minneapolis on this. But if you have substantial presence in both cities, I would imagine that both ordinances are going to apply to you. And I apologize, we're just doing the best we can on this because we have two ordinances that are not clearly written in a lot of respects. Does paid sick and safe time have to be tracked separate from PTO, or can safe and sick time be lumped into the generous PTO accrual? Well, there are two parts to that question. One is, if I have more generous PTO than the minimums required under the Minneapolis ordinance and the St. Paul ordinance, do I have to offer more time? And the answer to that, we're pretty clear, is no. But do you have to, even if you have a PTO policy, do you have to track the safe and sick time accrual and use? The ordinance does not deal with it. We're hoping that the answer to that, the ordinances do not address that. We're hoping that the answer to that is no, but we'll have to wait and see. Do backup on-call hours not actually work, have to accrue safe and sick time? I'm assuming we're talking about healthcare providers. The ordinance is silent on, the Minneapolis ordinance is silent on whether you have to track on-call hours. I'm not sure what backup hours are, but I imagine it's like on-call. Whether you have to track, whether there can be accrual of time based on on-call hours is only addressed in the Minneapolis ordinance for purposes of healthcare workers. It does not address on-call hours for non-healthcare workers. So my thought on it is, if these on-call hours are not considered time worked under the federal and state wage and hour laws, because the people are free to go about their business, they don't have to be on premises, I would say that those would not be considered hours work for the purposes of the Minneapolis ordinance. The company is based in this company is based in Minneapolis and has an employee who only works in Wisconsin. Again, the ordinances do not specifically address this, but I would say that the ordinance wouldn't apply to that employee. That would be an extraterritorial reach that I think would be incredibly unreasonable. Do you have a few more?
Sure. So this one asks, or it says that the business is headquartered outside of the Twin Cities. They do have an office space in Minneapolis for engineers to work on projects as needed. Must we comply with the Minneapolis statute for these employers? That's a tough question, one in which we have debated internally what the meaning of an employer inside of Minneapolis or St. Paul actually means. And so, unfortunately, we don't necessarily have the clarity yet, and maybe the guidance will show it. It is possible that the law will interpret an employer inside Minneapolis to mean that your office space inside Minneapolis makes you an employer in Minneapolis. I just don't know at this time. If that were the case, then yes, you would have to comply with the workers who work in the Minneapolis space if they perform work there. If the ordinance ultimately is not interpreted that way and only is interpreted in terms of headquarters, so that you are not headquartered in Minneapolis, then under the current decision of the district court related to the Minneapolis ordinance, unless you would not be covered, because as you'll remember, that decision excludes employers who are not within the city limits. So unfortunately, that's a very gray answer, but that's the best I can do right now given the information we have is maybe. Stay tuned. So another one asks if this applies to interns and seasonal employees and whether part-time employees are prorated. So, and correct me if I'm wrong, but I don't believe that the statute actually distinguishes based upon interns or seasonal employees. I assume interns, it depends if the interns are being paid. I think it comes down to whether if they are paid and they're paid employees, then they're considered employees. If they're true volunteer interns and are legally not being paid, then there would be no accrual requirement either. In terms of part-time employees, whether they are prorated, that is built into the accrual method. So if you'll remember, employees accrue 1 hour for every 30 hours they work. And so that is how they build in the part-time. If an employee is only working 30 hours a week, they're only accruing 1 hour per week, as opposed to employees who are working multiple or working more than the 30 hours. If that makes sense.
So if an employee has used all of their accrued and available sick and safe time and they call in sick for a scheduled shift, then they would not get paid for that shift, correct? Right. I mean, if they've used all of their sick and safe time and they don't have other available paid time under your policies, that time can be unpaid. And the way this is described, I'm assuming it's a non-exempt employee. Would that absence be considered unexcused since the employee did not have sick and safe time to use? That's a bigger question because we have all sorts of competing laws here. As a general rule, to discipline someone because they are sick, ill, disabled, et cetera, have a disability, personal disability, that's something you should probably check with your counsel on. It's going to depend on all of the circumstances there. Family and medical leave may apply, and they would be protected there. So that's a bigger question as to whether in a particular instance you could discipline the employee. But it's possible, yes. This is a question multiple of you have asked this question. Under the Minneapolis and St. Paul ordinances, if the employer chooses to follow that method of providing 48 hours as of the after 90 days of employment, and 80 hours for every, depending on which statute you're dealing with, calendar year, employment year, et cetera, thereafter. Do they also have to allow the carryover? My read of the statute is that they do not, because you're effectively giving the employees a minimum of 80 hours going forward. So that's my interpretation of the statute and of the ordinances. Is that yours also?
Right.
Okay. If an employee meets the, I had to make sure I understood the handwriting. It's better than mine, though. If a company meets the paid leave provision, I'm sure the person means the sick and safe leave requirements through a PTO policy, do they still need to designate and track the time that was used for sick and safe time? We're hoping not, but the ordinances don't provide for an exception, so we're going to have to seek guidance in that, because it's going to be a pain in the neck, frankly, to track that time if you already provide a more generous policy. Setting aside the problems with this, we allow unlimited paid time off on the honor system. Does this comply with the ordinances? Absolutely. If people are unlimited paid time off complies with everything under the sun, because the person can take time off for any time at anything at any time. Now, if you're going to deny somebody paid time off for a reason that's covered by the ordinance, please check with your lawyer and explain what the particular circumstances are there. I do have a not insignificant number of clients who have instituted unlimited paid time off policies. When I was first contacted about this, it was about 5 years ago. You know, we as lawyers tend to have conservative approaches because we think of all the myriad problems that can come from such a policy. But it is working very well for each of my clients that's instituted it. Their experience, this is anecdotal, but it's their experience. Their experience has been that, as is the case with most businesses, most of your employees are really good employees, right? Or they wouldn't be there year to year to year. And those folks don't take advantage of it. And when they need time off, they give you notice and they take a reasonable amount of time off and they come back to work. There are problem employees, and that's where the challenge comes. And so each time we have a problem employee that is saying, but you say that we have unlimited PTO, we've been dealing with that on a case-by-case basis. But so far, it's worked out. If we don't want to track 1 hour for every 30 hours work, can we grant the 48 hours up front? Sure, that's more generous. What documentation can we ask for when an employee wants to take sick and safety time to take care of a family member? I think that's going to depend on what the situation is. For instance, you know, if you're dealing with a circumstance related to sexual assault, stalking, things of that nature, I would be very careful to not unnecessarily invade the individual's privacy and the privacy of the family member. They usually can provide you with an order showing a hearing is going to happen, you know, something of that nature. I mean, use your judgment, but I wouldn't have them, you know, provide you with a criminal complaint, just some confirmation that they need to be absent for these days. This is an open question. Do you see your employers incorporating this additional sick time requirement into a current PTO program or as a separate sick time accrual? For most of my clients that have contacted me on this, they have PTO programs that are more generous than these ordinances. So we have tweaked their policies going forward to comply with some of the idiosyncrasies of the ordinances going forward, and we're watching for changes that may need to be made to those policies once the guidances are out and once we have more experience with this.
Here's another question related to documentation for stalking. So I think you covered that well, Anne. The second question on this sheet also asks whether the employer policy has to match the exact wording of the statutes. No. I mean, it should follow the substance, and that's where the help of an attorney would come in handy. But no, you don't have to have the exact wording in your policies of the statutes. As we've noted, the statutes aren't exactly well drafted and they're kind of clunky. So again, use your judgment, but consult your lawyer as to what the best way to word them in your policies are. This is another one related to accrual and tracking, which has already been answered. This one asks, if an employee calls in 1 hour or less before his or her shift starts and tells the employer that his or her family member is sick, does the employer have to provide paid leave under the Minneapolis ordinance? I think it depends on the actual situation of whether it checks out that the person did have to provide care for a sick family member. But in general, there really is no basis for refusing to provide that paid leave for lack of notice. And so in that situation, I would say, yes, that the sick leave probably does apply there. You have a few more?
Yep. Does the sick and safe time apply to sales reps who do not accrue vacation sick time currently? If the sales reps are W-2 employees, some sales reps can be independent contractors legitimately, but I'm assuming these are W-2 sales folks. And they don't accrue vacation and sick time currently. So I'm trying to think of my clients that have a lot of sales rep employees. I would say that they actually allow these sales reps pretty much unlimited PTO. A lot of them are paid a guaranteed base salary, and they can be absent as they choose to do so. If that's the case, I would say that, your policy more than complies. If you're going to deny them time off for some reason, check with your counsel. But if they aren't really entitled to time off under your policies, and they obviously wouldn't then you obviously wouldn't then be complying with the ordinances. So you would have to allow them the time off. There's probably more to this question, and I'm happy to answer in more detail if you catch me afterwards, or certainly give one of us a call.
That's not my question.
Oh, sorry. Go ahead.
That's not my question.
Oh.
Follow-up to that would be if you have several sales employees who are on a very low base but a very high commission, then what you really owe them when they take time off is that very small base amount.
That is an excellent question, and that is not addressed by the ordinance. I would say as it's now drafted, probably, most likely, Minneapolis and St. Paul, the councils didn't think of that question. As it's drafted right now, I would go with your interpretation. But we'll see. We'll see.
For the record, can you just repeat the question? Some of the people around the room and for the recording.
Certainly. I told you I'm not very good at following rules. And so the question, if I state it correctly, is how do we pay the sales reps for time off if they're paid a fairly low guaranteed base and then commissions on top of that? And the question was, do we just pay them based on the low base? And I would say yes, under my read of the ordinances right now. It is not addressed in either ordinance.
It actually is on one of your slides.
Pardon me?
It's actually on one of your slides.
Right, excluding commissions, but I don't think they're thinking of, the reason why I said I don't think they're thinking of it is because oftentimes that base is so much less than what their real income is year to year. So I'm wondering, you're absolutely right, as it's currently written. I know how these departments think and how they like to expansively interpret their ordinances. That's why I say I don't know definitively, but I would interpret it that way right now. Yeah. And maybe they'll take that approach. This is another question about, we have a PTO policy that doesn't break out sick and vacation time, which is typical. Do we have to segregate this usage for record-keeping purposes? The ordinance does not deal with it. We're all hoping the answer is no.
Excuse me, Ann, if I may.
Sure.
That was my question, and we have like a committee here, we just lump everything in PTO.
Right.
We don't have anything like, okay, 48 hours is to be used for sick only and the rest can be vacation time. And my concern is, okay, do we have to reserve sick hours?
Right. This is,
As opposed to 112 hours a year, you could take vacation if you want.
yes, the question is, the question's been more defined for me, that employers, obviously, if you have a typical PTO policy, don't keep track necessarily, unless you've got an FMLA going on at the same time, don't keep track necessarily of why the leave was taken, why the time was taken. What if all the time's used up, all of your, whatever your generous accrual is used up, and then in a 12-month period, and the person needs time off for one of these instances covered by either of the ordinances, do you have to provide extra time? We are hoping the answer to that is no. When I first read the statute, I said, gee, the way it's written, you could interpret it that if you've used all your time up to go to the Caribbean on a vacation, and then you have an unfortunate situation in your family where someone's been attacked or some other situation covered by the ordinance, doesn't the employer have to provide the minimum time? I think that would be unfair, given the ordinance as a whole. So we had differing opinions on that as to how the cities are going to interpret that going forward. And hopefully that will be one of the things that we get more clarification on. Thank you for June 30th, seconds before we'll need it, right? Jeez. Is that all the questions, or do
I
you
have a couple more,
there
and I
you
think there's
go.
a couple more minutes, so hopefully we can
Okay.
get through everyone's questions.
Okay.
So this one actually is really interesting. Relates to the timing of the different benefits that an employer might provide. So it says, what if we offer short-term disability program paid at 60%? Do they use the sick and safe hours prior to the short-term disability for one's own absence or FMLA? And again, the statute doesn't exactly address it, but I think that's right. I think under the statute, it requires that an employee for qualifying events gets paid at the rate at which the statute provides for, and that would assumedly be more than the 60% of the sick and safe time. So if they've accrued a full day off, they're entitled to payment for a full day off until they go through that, and then the 60% would apply. And then last question we have up here is, if an employer has hit the 80-hour carryover cap, do they stay at 80 hours or can continue to earn sick time in the next year? So what the statute provides for is an 80-hour cap. That's it. They don't accrue any more time in that year. So yes, if they hit that 80-hour for that year, they don't accrue anymore. And then once the new year hits, either if you're providing the time up front, or then they'll continue to accrue time once that year is up.
I have a follow-up to that. So those 80 hours, if they don't use them, do they carry over to the next year and then they continue to build on top of it and can only carry, or does it cap? So if they come into the new year with 80 hours, they don't accrue until they use them.
That's an excellent question. Let's see. Based on the actual wording of the statute, it allows for 80 hours to accrue, 80 hours to carry over. And then you can, I believe, and correct me if I'm wrong, what are your thoughts? So I would think that my thoughts are the 80 hours carries over, and then you can continue to accrue once that next year starts, but then you can't carry over any more than the 48 hours after that. Is that right, Ann? Based on your interpretation?
Say that again, I'm sorry.
Sure.
I was going back to the language of the statute, of the ordinance.
So my thought is, the way I interpret it, is that the 80 hours is carryover, and then you accrue from day one. And then it's capped at what you can carry over the next year.
So the Minneapolis ordinance says that you can cap carryover. The wording of this statute is problematic. I just have to tell you. So, but the Minneapolis statute says that you can carry over. You can put a cap of 80 hours on carryover. And it says that the total amount of accrued but unused sick and safe time for an employee may not exceed 80 hours at any time, unless the employer provides a more generous amount. We will be doing a flash focus as soon as these guidances come out. So please make sure you're signed up for our flash focuses, and you'll see those in your email.
So, yeah.
I have another question just in regards to relationships with temporary agencies. I'm assuming that if the temporary employee is paid through the agency itself, is it the agency that's required to provide the sick and safe time? Or is it the employer utilizing the temporary agency?
If the temporary agency is the employer, it would be the temporary agency, I believe. Yeah.
So the question on the clawback, when somebody terminates, the question I was asking is, what if the clawback then takes away paid time that was already given for sick? So a lot of companies have that. You grant your PTO up front, and then when they leave, if it's mid-year, if they've taken more than they've actually accrued in that time, you claw it back.
Yeah,
So the question is, if some of that time was taken for this, could you be in violation of the ordinance because you clawed some of that paid time back and it became unpaid?
the question is about clawbacks of PTO taken but not accrued. So if under your policy you have some mechanism for making adjustments at the time of termination or resignation of employment, if someone has taken more PTO than they have accrued, the question is, would that potentially be in violation of the Minneapolis ordinance? The Minneapolis ordinance does not require you to pay anything upon termination. So I'm.
It's not the payout, it's the clawback. We're taking money out of their last paycheck because they owe us.
Yeah, you know, I have to say that that particular practice can be problematic under other state law. I know some of my clients, and they just take the risk. I understand.
We do a sign-off, so we're good there.
If your policy is more generous, well, two assumptions. One assumption is, you know, that we don't have to track sick and safe time separately. If we do, then that's going to answer your question. If they have to have been provided all of their sick and safe time. But if you don't, I'm not sure that it affects it. Any of my partners in the room I see a number of very esteemed members of my department in the room. Do you all have any different, Ingrid?
Karen and I were just chatting. We don't think you can claw back any portion of the paid sick leave entitlement.
Yeah, that's what I was saying.
yeah,
that they have a
exactly.
PTO policy that's more generous.
Yeah, but let's say that the employee has used too much PTO by
Yeah.
their last day of employment, such that clawback would apply, the employer would have to be really careful that there
Yeah.
was no clawback of the 48 to 80 hours of paid sick leave, which would then practically require you to track how and why employees are using PTO,
Right.
which then kind of defeats the PTO system.
So it's really going to hinge on whether we have to separately track this time.
And if they say no, guarantee it'll get changed the first time it's come up.
Pardon me, I'm sorry.
I said, and if they say no, you don't, guarantee it'll get changed the first time this issue comes up.
Yes, our audience member is skeptical about how the agencies will approach this. I share that skepticism. It's likely to be quite broadly interpreted. Well, thank you all very much for this animated discussion, and we look forward to seeing you at our future seminars.